Welcome to the Oregon Athletic Directors Association Workshop Sports Law Year in Review. My name is Lee Green. For those of you who I've never had a chance to meet, I am a retired college professor. I taught for 30 years at Baker University, a small private liberal arts college located just outside of Kansas City. I retired from full-time teaching in 2016 to spend more time doing sports law research and traveling to various athletic director conferences. Although for this last year, of course, during the pandemic, those travels have been on hold. And I'm certainly looking forward to coming back to Sun River in the future. I've been there a number of times. It's such a beautiful place, but as an alternative, doing this workshop virtually is kind of the next best thing. There is a handout to accompany this workshop. And the handout, I tried to go almost a little bit overboard in terms of making it very thorough. It probably has 5 times as much information as I'll be able to present in the time that I have here today. And so make sure you download a copy of that handout. Dave Hood was going to make sure that it was either emailed to all of you or placed somewhere where you could easily download it. But the way I've got this workshop organized is I wanted to touch on all of the key issues that are really impacting athletic programs right now. And I've got this organized by categories. So issues like the constitutional rights of student athletes, liability for sports injuries, Title IX compliance, hazing in athletic programs, sexual harassment in athletic programs, disability law applied to athletic programs, on and on. And so the first category is one that I've never included in a workshop in the past, but I thought I would put a little bit of information, and that is legal issues related to COVID-19. And I've got this broken up into the categories of the lawsuits that have been filed around the country or we can anticipate being filed related to COVID-19. And the first one, we've had quite a few lawsuits that challenge the postponement of sports seasons. And these first started to be filed last spring as a lot of schools canceled sports seasons at the onset of the pandemic. And then in the fall of 2021, a lot of lawsuits as schools postponed, based on the recommendations of public health authorities, some of their fall sports to the winter or to the spring. And a typical example, a case out of the state of New York, Mermigas versus Cuomo, the New York State Athletic Association, and Niagara Falls High School. And this is basically challenging their postponement of the fall 2021 football season to the spring. And the court ended up ruling in favor of the state association, and the high school really upheld the decision of the public health authorities and basically said, we're in the middle of a global pandemic. We've got to go with the recommendation of the public health authorities. And the court actually made a statement that the postponement is a wise policy. The court owes a great deference to the protective measures ordered by public health authorities in regard to the COVID-19 crisis. And this is essentially what courts all over the country have ruled in these postponement of sports season cases. Now, in some of the cases, public health authorities, based on changing numbers of positive tests for COVID and so on and so forth, the public health authorities themselves actually ended up changing their recommendations, and that allowed sports seasons to go on. And I've got a number of cases where that happened included in the handout that you can take a look at. A second category of lawsuits were those where, even where the sports took place, there were challenges based on limits to crowd sizes. And the County of Butler v. Wolf is a U.S. Third Circuit Court of Appeals case out of Pennsylvania on that exact issue. And the public health authorities in all sorts of public settings had limited the number of people that could attend different events. And there predictably were some parents who, and when I say that, I'm not trying to denigrate parents of student athletes. I know 95%, 99% of the parents are great, but there's always a few that will challenge everything that schools and athletic programs try to do. And this was one such case. And it was typical of these type cases around the country. I have several of them mentioned in the handout. And the challenge really was based on, well, they're doing it differently in the neighboring county. They're allowing more fans, or they're doing it different in the state just to the north of us, or the state just to the south of us, or the pro sports teams in our area are allowing more people in. And none of those comparisons were actually convincing to courts, who uniformly ruled in favor of the protective measures that were recommended by public health authorities. So that is kind of good in both of these cases, to see courts siding, in the best interest of public health. Liability for contracting COVID. There are no lawsuits yet that have been filed on this, but it's almost inevitable, especially given what's happened over the last few months with some of these variants affecting young people more and more in several states where they had postponed sports seasons. There were challenges to that. And then we ended up having quite a few student athletes who contracted COVID-19. But the likely key issue will be, these will be negligence cases, like these cases always are. And so the burden will be on the schools to show that they exercised reasonable care to prevent student athletes from contracting the virus. And that'll really be a matter of, did you follow the health protocols that were laid down by your local authorities, by your state association, by state law, so on and so forth. And one thing to keep in mind with this is, you think, oh my gosh, people are challenging the postponement of seasons, but then when a kid contracts COVID from, some close contact sport, wrestling, football, whatever it might be, then the family's going to turn around and sue us. Well, keep in mind that courts have uniformly over the years, with regard to liability for sports injuries, they have been very clear that schools and athletic personnel are not the 100% absolute guarantors of the safety of student athletes. You just have to exercise reasonable care. And that's kind of a sliding scale. And you're not, if you think of it as a scale from 0% care to 100% care, courts aren't looking for you to reach that 100% level. Now, courts, of course, never define this in terms of percentages, but they're looking for you to move as far up that scale as is reasonable, given the nature of the circumstances that were involved. So if you followed all the local protocols and did the most that you could, given the logistics of the situation, I think you're probably going to be safe. One issue that is related to this is, unfortunately, I think a lot of schools are relying on the fact that they have insurance for their athletic programs, and therefore they assume that that insurance would cover any lawsuit that a family would bring related to a student athlete contracting COVID. But most insurance coverage around the country, they have added insurance coverage of sports programs. They have added exclusions related to COVID-19. And for instance, there's one big insurance pool known as ALICAP. and they insure sports programs all over the country in different states. And they recently, for instance, in Nebraska, they insure the sports programs like 175 schools in Nebraska. ALICAP is actually backed by Lloyd's of London, which isn't an insurance company, it's an insurance market. But that's how, with some of this sports insurance stuff, the insurers lay off their risk to some big syndicate like Lloyd's of London. And that's what ALICAP has done. But ALICAP has notified all those schools in Nebraska that it insures, and again, around 175, that they have included specific written exclusions that their policies don't cover COVID-19. And therefore, don't assume that any insurance coverage your school has covers COVID-19. Those insurance policies may not be bulletproof, so to speak. You need to really look at the precise language. Another issue is that a lot of schools are asking student athletes to sign COVID waivers, that the student athletes and their parents would also sign, agreeing not to sue the school if the student athlete contracted COVID. Well, there haven't been any lawsuits yet on this particular issue involving a waiver, but lots of courts around the country look on waivers of liability the student athletes sign with extreme disfavor for several reasons. First of all, high school students usually are minors and don't have the contractual capacity to sign a waiver. And then also a lot of courts, even if the parents have signed it, a lot of courts don't like the idea. They feel like it violates public policy of parents being able to waive away the rights of their minor children. They want those minors to retain the right to bring a lawsuit after they reach the age of majority. So bottom line, these waivers of liability, just like regular waivers, exculpatory clauses, hold harmless, whatever you want to call them, they also are not bulletproof. So don't assume that just because a waiver is being signed that you're going to be insulated from any liability if a student athlete contracts COVID. Now, I'm not saying that waivers are, useless or are not worth having student athletes sign. A lot of court cases, the waivers, because they were so sports specific, served as good evidence that you had warned student athletes of the risks of participating, but the only type of risk that you can actually sort of foist onto the student athletes using the assumption of risk doctrine are risks that are inherent to the sport, and that wouldn't be the case with COVID. So bottom line, those waivers of liability may not be very useful. Another type of lawsuit that I think we'll probably see a lot of coming up here in 2021 throughout into 2022 are where student athletes have refused to get vaccinated. And the issue is whether or not you could suspend those students from athletic participation if they refuse to get vaccinated. Now, right now, 45 states have state laws requiring certain vaccinations for students before they can attend school. But all of those state laws have, in the 45 states, have religious exemptions. A few of the states also have exemptions based on philosophical and moral grounds that families can make. There are 5 of the states that don't have any exemptions to their vaccination requirements. But bottom line, what if it's the COVID-19 vaccine that a student athlete's refusing to take? Well, we haven't had any lawsuits yet on the issue, so I can't say for certain what the outcome would be. But in 2019, before the pandemic, there was a case with a high school basketball player in Kentucky, last name Kunkel, and I have a lot of detail about this case in your handout. But there was an outbreak of chickenpox at his school, 32 cases in a small school. And he was a basketball player. And so the Northern Kentucky Health Department, they weren't going to allow the entire team from Kunkel's high school to go to the state tournament because of this outbreak of chickenpox. They were afraid that a lot of other in close proximity student athletes and people attending the state tournament, that there might be an outbreak of chickenpox across the entire state of Kentucky. Now, they reached a compromise where they allowed the student athletes on the basketball team to take a test to see if they had the antibodies that would prevent them from getting chickenpox, so on and so forth. But Kunkel's family was opposed to that. They had been opposed to vaccinations and were opposed to the test. And they challenged in court, basically arguing that their son had a right to play in the state tournament. And the court ended up ruling in favor of the Northern Kentucky Health Department. And they made several very clear statements. I got those quoted in the coverage of this case in the handout, but that the priority is a community protecting against the outbreak of a highly infectious disease. And that language, then, a year later, this case decided summer of 2019, when we had the COVID-19 outbreak, I thought, well, this is going to be an interesting case that I think is going to get a lot of play, the Kunkel case, in terms of once we do have a COVID-19 vaccine, which we obviously have several now, if schools decide not to let student athletes participate who haven't been vaccinated. So kind of a wide range of legal issues related to COVID-19, and be very interesting to see how these trend in the future. Now, changing topics, constitutional law, free speech and social media, a case out of the U.S. Third Circuit Court of Appeals where a young woman, a cheerleader, made a posting on Snapchat that included her and a friend who wasn't a cheerleader, but the two of them extending their middle fingers to the camera, and then a caption that included the F word several times, where the cheerleader basically said, F cheerleading, F softball, private softball team she played on, F school, F everything. And when screenshots of this posting, of course, with Snapchat, the postings disappeared pretty quickly, but there were some screenshots that made their way back to school officials. And this cheerleader, she was just a sophomore. She ended up being really, you could call it a suspension. She was booted from the team, but told next year you can try out again. So in a way, it was a 1-year suspension. But bottom line, the U.S. Third Circuit Court of Appeals, she had done this posting off campus. And the Supreme Court precedents in the Tinker versus Des Moines case said you can only suspend a student or student athlete if their postings, if their communications, if their speech created a substantial and material disruption of the educational environment, which is cheerleaders' postings did not. And then the Bethel School District v. Frazier case that said schools only had authority over profane, lewd, vulgar language that took place on campus. And that also did not apply to this cheerleader. So bottom line, the U.S. Third Circuit Court of Appeals ended up ruling that the cheerleader's free speech rights were violated by her dismissal from the team. Now, the U.S. Supreme Court actually agreed to hear an appeal of this case. And we've been waiting a decade for the Supreme Court to agree to hear an appeal of a free speech social media case. And it was in January they agreed to hear the appeal. April 28th, the oral arguments were held, and you can find those oral arguments online, the audio. Of course, the oral arguments were conducted by a phone conference between the justices. They're still not holding oral arguments in their courtroom in the Supreme Court building. But a ruling in this case is expected in late June of 2021. And what the court's going to have to do is lay down a legal standard that really works. It's always been kind of square peg in a round hole, trying to apply the old student free speech precedents to modern day, email, text messaging, social media, et cetera. So the Supreme Court is going to have to lay down a legal standard that applies in this to modern technology. And it'll be really interesting to see what they come up with, because they're going to want to strike a balance. They're not going to want to limit the rights of students to engage in political commentary. And, suppose the cheerleaders posting had something to do with social justice issues or national anthem protests or gun control or some other real political type topic, as opposed to just sort of a rant that the cheerleader went on in this particular case. The Supreme Court is not going to want to restrict student political speech, but they are going to want, I think, to allow schools to take advantage of teachable moments and have some control over these teachable moment type situations. So keep your eye out. And again, you can go online and listen to the oral arguments in this case, and they're very interesting. There were 3 attorneys that argued, one for the school district and 2 for the student athlete, and each attorney had about a half hour, and all of the justices asked multiple questions, including even Clarence Thomas, who's known for, he wants to rely more on the written briefs in cases. And he actually asked a couple questions of each of the 3 attorneys. So you could tell the justices were very interested, but they didn't really tip their hand as to how they're going to rule. So very important case. A case involving constitutional law, freedom of religion, and prayer before sports events. This one's out of the state of Washington, and so up there in the Pacific Northwest. I'm sure you've all followed this case over several years. Joe Kennedy was a football coach at Bremerton High School who was kneeling on the field to pray after games, and he would often gather his own players around and players from the other team. And his school district, its attorneys, felt like this violated the Establishment Clause, which prohibits the government from being involved in any type of prayer activity at school, the government or government employees. Now, certainly, I think everyone's in favor of, students in schools and student athletes getting moral guidance from teachers and coaches, on and on. But the only thing that Establishment Clause in the First Amendment really prohibits is the involvement of government and government employees. And no doubt here, he was a coach at a public school, and he was fairly involved. Now, to make it very clear, Supreme Court precedents, and I talk in the handout about the Santa Fe ISD v. Doe case, which is the landmark Supreme Court case on prayer at school sports events, makes it very clear that student athletes can pray. Students and student athletes can pray on a high school campus anytime they want. A student could, before a big test, put his head down and say a prayer, or in the lunchroom before she eats lunch, she could put her head down and say grace, or a sports team could spontaneously in the locker room or on the field, take a knee and engage in a prayer. But it's just the government that has to stay out of this. So if you really want your student athletes to be able to engage in prayer activities, make sure that your school officials and school coaches stay out of this. Now, this is obviously different for private schools who aren't bound by the limits of the First Amendment. But this case actually got all the way to the Supreme Court, and the Supreme Court refused to hear an appeal. But several of the conservative justices on the Supreme Court, usually when they deny an appeal, it's just a 1-sentence refusal of certiorari. And in this case, though, 4 justices, Justice Alito, writing for the 4, said that they thought that Kennedy actually had some interesting freedom of speech and free exercise of religion arguments that this case should have considered. So the Supreme Court didn't require this, but back in the state of Washington, both the district court and then the Ninth Circuit Court of Appeals, in January of 2019, they basically ruled against Coach Kennedy again and said that the Establishment Clause overruled any free exercise of religion or free speech rights. But bottom line, again, this limits only the state actors, the public schools and public school employees themselves. Cambridge Christian School, an interesting case out of the state of Florida with a private school that was playing in the state championship football game a few years ago, and they wanted to use the PA system at Camping World Stadium, the big stadium in Orlando that hosts pro games and college bowl games, etc. But the stadium was funded by public money and is ran by public money. And then the state association in Florida that was actually the sponsoring entity for the state championship game, it's a public entity. So the belief was that because of the involvement of a publicly funded sports venue and a public organization like the state association, that it would be a violation of the Establishment Clause to allow this school to actually use the PA system in the stadium for a pregame prayer. Now, this did not end up limiting the Christian school from doing a pregame and postgame prayer. They just gathered the team, their coaches, fans on the field, both before and after the game, and did a prayer. So it didn't actually limit their ability to pray. It was just the use of the PA system. But after the game, they've challenged this, and this has been bouncing around in the courts. And the U.S. 11th Circuit Court of Appeals has said that there are enough issues here about whether or not this really would be an Establishment Clause violation, that this needs to go to a full trial, and a full trial is expected to be held later this year. Constitutional law, equal protection and discrimination. This was a case out of Texas with a grooming code resulted in the suspension of a couple of black students who were involved in a variety of school activities because of their dreadlocks. And the U.S. District Court said this was very clearly a violation of equal protection law, not allowing these students to, suspending them from school and extracurriculars because they wore dreadlocks. There wasn't any intent here to discriminate, but that's irrelevant if some sort of hair code, dress code, jewelry code, whatever, unless there's some really strong safety argument that can be made. If the policy has a disproportionate impact on persons of a certain race, ethnicity, religion, gender, etc., then this violates equal protection. And a lot of you probably remember the case from 2019 with the wrestler at Buena Vista High School in New Jersey who was forced to cut off his dreadlocks or forfeit his wrestling match. And that got a lot of play nationwide. I think I first saw the lowlights of it on Sports Center. But soon after that event, the New Jersey Division of Civil Rights and their state attorney general issued an equal protection guidance that said this type of policy clearly violated equal protection principles. And the kid was going to wear the required head covering for safety purposes, and they still made him cut off the dreadlocks. So be very careful about your dress codes, hair codes, etc. Transgender student athletes, on the night of the inauguration, January 20th of this year, that night in the Oval Office, President Biden signed an executive order 13988 titled Preventing Discrimination Against LGBTQ Persons, and basically making it clear that he was going to reinstate the policy that really had been the policy since 1993 through Bill Clinton's 2 terms in office, through George W. Bush's 2 terms in office, and through President Obama's 2 terms in office, that the word gender in Title IX referred to gender identity, not gender at birth. and also that equal protection laws prohibited discrimination based on either sexual orientation or gender identity. Now, all that, of course, changed a lot in the last 4 years with the policy of the administration reinstating a lot of the I'm not sure what to call them, restrictions based on sexual orientation and transgender status, both in employment, in education and healthcare, in the military, etc. But this executive order trying to reverse the course of that. Now, there was a OCR complaint filed against the Connecticut Athletic Association and a bunch of districts, and a parallel federal lawsuit that basically challenged the participation of transgender girls in girls' sports in the state of Connecticut.